we thought that it would be interesting to have also the practitioner point of view, not only the academic or very abstract point of view, but also the perspectives from practitioners and also different institutions. So we will have in this first panel different views from different actors at a very political maybe and also diplomatic level.
I will be jointly managing this interesting panel that I look forward to your discussions with Amandine, and between Amandine and myself we will just try to see that you are disciplined in terms of the time, and as we said, we have now 2 panelists and hopefully the other 2 will join. We can just start off by making some small introductory or short introductory remarks, especially in the area of work. And then also, as we've said, when we communicated earlier, is that you can also share your personal perspectives after your rich working experiences that you have had or are having. So at the moment, we have 2 of our panelists present. We have Jarek Reekseidler. He is a senior political affairs officer at the Mission of Canada, someone with a wealth of experience, especially in Europe, having worked at the Canadian mission for many years, has been linked to the Canadian delegation to NATO, and it is also someone who has studied at the European College in Bruges. So Jared will share those experiences with us that he has encountered in his working life, and I can just say I know Jared through also some working experiences, and he has been very active on many fronts in terms of democracy, rule of law, and all these other issues related to human rights, etc. He's also active as a civil society advocate, so he has wide experience. I think everyone will benefit from his perspectives. Amadine, maybe you can just briefly introduce Igor, and then we can start our discussion. And as is in the program, Jared, since you are there already, then you can start off after Igor is being introduced. Amadine,
yeah, good morning.
To you.
Thank you, Andrew. Good morning, everyone. The introduction of Igor will be very brief. We are very happy that Igor Rabi joins us this morning for this debate, this roundtable on the rule of law from the perspective of the practitioners. Igor works at the permanent representation of the Republic of Moldova to the European Union in Brussels. He's based in Brussels, and his main area of work is rule of law, and I'm sure he will further introduce himself at the beginning of his presentation. I think we're set for an interesting roundtable this morning, and it will be very stimulating to hear about all your different perspectives on how to apply rule of law in practice. So the floor is yours, Jared. Thank you.
Sure. Can you hear me okay? Well, good morning, everyone. It's as we all get used to this video conference technology, it's always a bit of a learning curve for sure. And I feel unfortunate that I can't see all of your faces because I'd like to get to know all of you during the interaction as well. I'm a big believer in question and answers and having more interactive format, so I will try not to speak too long, but please let me know if I don't respect that modality. I just kind of looking at your kind of overarching question, is the rule of law challenging global governance? I think if my interactions with Andrew beforehand, we didn't, I just wanted to make sure that I have a sneaking suspicion, perhaps some of you don't know domestically how we organize ourselves in Canada. So I thought just I'd spend a couple minutes just going very quickly tour d'horizon of rule of law in Canada, and then we can look a little bit at the global dynamics. In my job at the Mission Canada to the European Union, I spent a great deal of time looking at the EU itself and the rule of law situation and how that relates to Canada. So that's probably where I have the most fresh thinking at the moment, but also as that relates to global governance and the future of the rules-based international order. So I'm happy to talk to you about that as well. So just I'll kick it off this way. For those who don't know Canada, excuse me if this is a little bit too basic for you, but I think most of you know that we are quite a decentralized federation with quite a strong influence of our British colonial history on our institutions and then the way the rule of law functions. But there's also a very strong French component to that, linked to the fact that part of our country used to be under the French Empire as well. So essentially, in terms of, I'll just start at the very top with our constitutional history. Canada became independent in 1867 with an act called the British North America Act, which created what has ended up evolving into one of the most decentralized federations in the world, to the same extent as maybe about Switzerland and Belgium in comparative purposes. So all to say is that the constituent entities, the federated entities, so in our case, the provinces, 10 of them, and 3 territories, but particularly the provinces, have great deals of autonomy and in our balance of competencies between the sub-federal entities in the federal system. For that evolved over time. The other major marker I wanted to kind of set off for you is in 1931, there was an instrument called the Statute of Westminster, and that basically gave Canada the right for the first time to conduct its foreign policy and external relations as a quasi-independent entity. And a lot of that was linked to our experience during the First World War, where Canada, in essence, people tend to think that the birth of the Canadian nation came with our experience in World War I, where we were, very, very strong contributors to the effort of the British Empire, along with our New Zealand and Australian and Indian and other colonies, troops to the war effort, and a couple key victories in a few wars. One was called Vimy Ridge, and also our efforts in the Battle of Passchendaele in Western Belgium led to us getting a seat at the Versailles Treaty table, and eventually the Statute of Westminster, which allowed us to fully conduct our external relations policy in that vein. I'm just going to go really, warp speed here to 1982. I don't know if you've heard of a person called Trudeau, but we're not talking about Justin. We're talking about his father. Pierre Elliott Trudeau is probably our most well-known prime minister overall. It was an obsession of him to conduct what we call the repatriation of the Canadian Constitution. So in 1982, we adopted our Constitution Act, which for all ifs, ends, and purposes really gave Canada full independence in any respect, including because until that point, if we wanted to amend our own constitution, we still had to go to the sovereign in the United Kingdom to be able to do so. And as of 1982, it became solely within the Canadian jurisdiction to be able to make such changes. And included in that Constitution Act was, I would say, the most important thing I'm going to say to you today is we adopted as well what's called the Charter of Rights and Freedoms, which is very similar to the Charter of Rights of the European Union, but we were a couple decades ahead on that front. It basically lays out all of the individual rights and the protections that we have within Canada, including in its preamble a core reference to the importance of rule of law in terms of upholding Canadian society and protecting Canadians' individual rights, and that all Canadians are equal before the law. Just a couple of things I'd add to that is, it's quite natural for us to always make comparisons with the United States. And a professor said to me a couple of years ago, and I think it really stuck with me, is that so much of Canadian history, in comparison to our American cousins, is, this is very simplistic, but in many respects, the history of United States has been forged through revolution and in many respects, overthrowing of authority. Whereas in Canada, our whole culture is defined by being counter-revolutionaries, to a sense that many, British loyalists during the American War of Independence fled to Canada. Our national motto is peace, order, and good government, which sounds very, very boring, but it says it all about the way our rule of law functions in Canada. I think a couple of key characteristics of our system is, obviously, like any country that aspires to have strong rule of law, we have, we hope to have full independence of our judiciary. The way our court system works, it's delineated in a federal structure. So we have our Supreme Court of Canada, which is the overarching authority and the final word on our judiciary. But we also have most cases go through the provincial courts unless they need to go up to the federal level, either because they concern a federal jurisdiction or B, that's you need the final word of the Supreme Court. I think one thing that's a little bit different than many countries is judges in all of our court system they don't start off as judges early in their career. They usually always go through as a lawyer for probably a good 20, 30 years before they're in a position to be appointed as a judge. And I think that experience is quite helpful for our system, that we don't necessarily have to train judges in it, and you don't have that worry about having a lack of experience. I see that in a few European jurisdictions. That's a little bit of a difference. Secondly, the nature of our civil service, I think all civil services aspire to be apolitical, but I don't think that's always the case in reality. In Canada, I think we've more or less succeeded in that, in having a very, very huge chasm. Our national motto of our national public service is fearless advice and faithful implementation. So essentially what that means is that our apolitical public services gives the best advice we possibly have, given our own logical and rational reading of the situation, including consequences for different options. But once our political masters take a decision, then we faithfully implement that. So the idea is that we are not already self-censoring ourselves when we're giving that original policy advice because we're not sure of what the minister or the government would like or not. So I think that's quite important. And then just one other thing I think is really unique about the Canadian system is we're more or less a common law jurisdiction like the United Kingdom, but we do have one big exception, which is Quebec, which runs under a civil law system. So we do have a hybrid system. I'm not aware of any other country in the world that has such a peculiarity. So that does make a little bit of a difference. And then a couple of last points, and maybe I'll stop it there, is for the Canadian side is obviously the freedom of our media is essential to our ability to uphold and keep our political masters to account. At the moment, I don't know if you've heard of a situation of a certain Huawei executive that's been asked to be extradited to the United States at the moment, because this is the biggest court challenge we have in Canada at the moment to our rule of law system. And the court just said this week that they were willing to go forward with hearing the extradition. I just want to underline that because Canada is becoming under a lot of pressure from China at the moment over this case. And I think it really attests to the independence of our judiciary, that our government in no means, even if the temptation would be there to have any kind of interference in this case, because to the point that we've had two of our nationals taken, arrested in China on what we would consider baseless charges, there's been no movement in our regard to try and even make any kind of illusion of us having any kind of influence on the judiciary system in Canada. So I think that really attests to just how strong that culture is in Canada, and it's a really key component of our relative stability and prosperity as a country. I just say quickly on the international scene, I spend most of my time looking at the rule of law situation in Europe and the European Union. Through both the Council of Europe lens, but also the EU lens, we're watching with great interest some of the backsliding we're seeing in a couple of countries. I'm just speaking personally, but we do have some concerns, that's for sure. Unfortunately, it's a bit of a strange situation because after the end of the Cold War, I think we got to a point in Canada where we thought that the European continent, for the most part, was after the Yugoslav wars, I should say, had a degree of stability that we could put our energy into the rest of the world, and that part of the world would more or less take care of itself. But I think we're starting to see enough serious signs of concern that we're struggling a little bit to see how we can best support those efforts to strengthen a rule of law across the continent and to help overturn some of this backsliding that we're seeing in a couple of countries. So I'm happy to talk to you about that. That's a bit of a fluid concept because we're not throwing that many resources in, but we're really looking for fresh ideas on how we can most make use of our own resources and networks to help support those actions. We're also an observer in the Council of Europe. I have been over time one of our deputy permanent observers at Council of Europe, so I'm happy to talk about that a little bit. And then lastly, just looking at the global picture, I think Canada, and I think we share that concern with the EU and key member states such as Germany and others. We're very concerned about the deterioration of the rules-based international order. We're looking for ways to reaffirm the importance of multilateralism to make sure that an efficient rules-based system works for everyone, because I think it's very, very clear, especially for the smaller countries and not the big powers, that we can easily get squeezed in a situation where great power politics is coming back onto the scene, and it's making for a very unstable global environment, which hits not only our economic prosperity, but our political and geopolitical stability as well, and our ability to influence the world scene in a way that works for advancing the dignity and individual rights of all persons. And for Canada, we're very, very concerned of making sure that democracy, human rights, and rule of law are upheld across the world. And we're not the biggest player in the world, but we do what we can to advance those causes. And we're hoping, I'll give a little plug here, we're hoping to be elected to the UN Security Council in the next couple of weeks, because we'd like to be able to play that role at that level of global governance in a way that we've not been able to do for quite a long time now. So I'll stop it right there, because I think the questions will help guide for the rest of the conversation. Does that sound okay?
Oh, thank you, Jared, for that rich presentation. What I take from your presentation is that in the Canadian system, you have an experienced judiciary. The lawyers and the judges are experienced, and then also the civil service is apolitical. And then the concerns that the red flags that you've seen for Europe is the backsliding, and also to further work on the promotion of multilateralism in global affairs. No, thank you for that. Igor, it's now over to you to share your experiences, also personal views from Moldova.
Thank you, Andrew. Good morning to everyone. So just to start with two things. Speaking about rule of law, we mostly refer to judiciary, but I want to start with one important thing. We are the government, so we are not the judiciary. And from that perspective, judiciary normally judges us and states where we are wrong as government in each and every country. So from that perspective, it should be understood that the position of the government is promoting reforms in this domain, but some of those could also be considered non-conform to the rule of law, namely by the judiciary. Just a couple of words about the structure in our case. The country is quite small, so about 3 million of people, centralized from that perspective, not a federation, and the court system is one single system for the whole country, 3 stages. So the Supreme Court, the appeal courts, and the basic normal courts. One single system without specialized ones for now. Independence, normal thing for judges. Just to touch upon the issue which Canadian colleague mentioned about the experience, it was mostly the same for many years, but as a consequence of our discussions with the Council of Europe and with the European Union, the system was changed something like 10 years ago, going to the one single entry point to the system. There are still 2, but this is the main one for newcomers. So going to a specialized training institution, National Institute of Justice, via which judges and prosecutors enter the system. So it is important from the mentality point of view. I have seen, being a law student, I have seen the difference between the judges being the judges from the beginning and judges coming from prosecutors and from the lawyers. And this is not about the position, this is about how people think. And there you see the difference. But this is what is changing slowly, but stage by stage, the mentality. The second path to justice and to prosecution also remains. So the possibility to pass via exams at the National Institute of Justice, being an experienced lawyer, so not being obliged to take the courses, excluding the basic one, because the basic one is for everybody, but you can take the exams. So this is about the system as such, and now going more to the specific of our work as a mission and as a Ministry of Foreign Affairs and European Integration. I have been working there for nearly 12 years, and in our case, we are treating justice and the rule of law part, namely as a part of the European integration process. We are the key coordination body, Ministry of Foreign Affairs and European Integration, and the mission is an interface in relations with the European Union on all the issues, but including on this one. Just one specific moment which is important to mention here. If we speak about legal part of our relations with the European Union, this is the association agreement. And if you look into that, you will see a rule of law just a couple of times and in a specific context. You will see it in the preamble, so in political part, as a common value which is at the basis of the EU, but at the same time is at the basis of our relations with the EU. And you see the general commitment to strengthening rule of law. After that, basically, when we go to the text, we see rule of law as a general principle, which is governing the association agreement as such. We see it as one of the topics being discussed within the political dialogue with the EU. We see it as one of the topics for cooperation in the domestic reform, and in the most detailed manner, it is described at the legal level in Article 12, which is named rule of law as such, and it refers namely to the cooperation in the freedom, security, and justice fields. And here there are mentioned specifically three aspects of the rule of law. So independence of the judiciary, access to justice, and the right to a fair trial. Why I'm mentioning specifically what is the what is in the association agreement in the rule of law? Just a couple of mentions. Association agreement, it's hundreds of articles, but the rule of law is mentioned just a couple of times. So at the legal level, you have quite a few mentions, and the explanation is quite simple, because at the EU level, rule of law is not codified as such. So it's not like normal process via regulations and directives. So it's in a different way. And all the other hundreds and hundreds of articles go for normal economic sectoral cooperation, where the normal transposition mechanism, where the mechanism of harmonization of legislation. But this brings it to the specific of our relations with the EU. So you have not a very specific legal base, and after that, you go to political ones, you go to political documents, you go to association agendas, which are planning documents in our relations with the EU, and you go to the political declarations from the both sides. This is important to understand from the perspective that here, namely in the rule of law, you have just a couple of issues which are quite clear from the implementation perspective, and interpretation is really narrowed, so you are sure what you are doing. For example, one of the things linked, which is coming from economic field here, it's money laundering. There we have one of the rule of law related field, which is well regulated at the EU side. We have it as one of our obligation for transposition in national legislation, and here you do quite a clear work. So you discuss how you transpose the EU directive into the national legislation to ensure the relevant standards. But this is one of the few exemptions when we have such cases, because for the most aspects we don't have EU law on that. What is brought in this case is good practices and the Council of Europe experience normally, but here you are not in the field of clear, hard law. You are in the field which could be interpreted, and this is one of the minuses, I would say. Not minus in what sense? Minus is that it depends on the political opportunity issues from both sides. From our side, when we speak about politicians, colleagues from Canada well mentioned that we as public servants, we make the proposals, we put the options on the table, we do the recommendations, but decisions are taken at the political level. And the decisions could be different in this case depending on what is the situation. And we had those concrete cases. For example, 2015, Prime Minister and President of the Parliament asked for the peer review on justice from the EU. So to assist us. It was politically an important move, bearing in mind the internal situation and the interest from the EU for that issue. But when we go to the details, to the implementation, what counts for me? So what is the practical implementation and what is the impact as public servants normally work with? When we see quite a general peer review, which formulated recommendation, which was a short-term mission of experts, people were quite experienced, but from different countries and with quite general terms of reference. And then the result is that you have a general assessment of the situation from point of general experts having different institutional and legal system background, and their recommendations were controversial between them, and in some cases controversial with the official positions of the EU. I will give a concrete example. During our visa liberalization process with the EU, one of the issues was corruption and the procedure for appointment of the head of the National Anti-Corruption Center. And the idea was to do depoliticization. It will not be appointed by the government, it will be appointed by the parliament. And it was officially assessed positively by the EU for visa liberalization process in 2013. In this peer review 2015, we got that this is not a positive thing. And in order, once again, to depoliticize, we should get it from the parliament back to the government. And it was clearly linked to the political situation back then. So this is the issue I would like to bring the attention to, that when we speak about the soft law, about the best practices, then we always go also to the issue of political opportunity from our side as Republic of Moldova, but also from the EU side. We have had such experiences also. For example, the recent case when previous government proposed and introduced the mechanism for additional mechanism for selection of the general prosecutor, so a governmental commission which pre-selected the candidates for the prosecutor general. It was, as procedure, it was at the moment last year generally supported by the European Union, but quite recently it was declared unconstitutional by the Constitutional Court. So here, even if politically in our relations with the EU, it was considered from the point of view of governmental officials, so the government of the Republic of Moldova and European Commission were in favor of this measure. At the level of rule of law control, of the judiciary control, it was considered not corresponding to the rules. So this is one more thing when we speak about the political opportunity and the control of the judiciary over it. And just to finalize with the EU assistance to us in this respect, EU is assisting the Republic of Moldova in reforming justice, so in consolidating rule of law. I already mentioned this technical assistance, so peer reviews, or also seminars which were organized last year, for example, namely on that part on justice reform. These EU could do, and here the important thing is that the EU gives money. Expertise comes from the member states, from the Council of Europe, in some cases from the Commission in some specific cases, but normally it is not the EU as such experience. The second part is the financial assistance. Sometimes it is possible. In this case, I speak about the direct one. We have the experience of the budget support from the EU for justice. And potentially possible, once again, depends on what will be the conditionalities, how realistic they will be, and what will be the assessment. In our case, 2 first tranches were disbursed. After that, 2 last ones were not disbursed, and the assessment was the general, the reason was the general one, so the insufficient level of reform in justice. One more thing which should be mentioned when we speak about EU assistance. The previous two forms, so the financial assistance and the technical one, are the direct EU assistance. But at the same time, when we speak about rule of law, the important contribution is also given to the Council of Europe, because the joint programs which are implemented by the EU and Council of Europe are much more consistent, and they should not be taken out of the picture when we speak about our cooperation with the EU on the rule of law, because this is the important part. Council of Europe has experience, expertise. EU gives money, so the assistance could be given to the Republic of Moldova in this perspective too. With regard to the, these are the main forms, which is the EU possible direct assistance to us. The political aspect I mentioned previously, so the political documents for cooperation like association agenda, they normally have these elements on justice reforms. Their concrete content depends on a couple of elements. The issues which are important for the EU, the issues which are identified as important by the Council of Europe, by Greco, for example, by Venice Commission, depending on our cooperation, and at the same time by local civil society. So here you see that the content, once again, is flexible, so it's not an issue of clear legal norms which are the basis for future reforms. You have the issues which depend on the current situation too for each and every moment. But here, once again, not to create impression that there is no coherence there. Normally, the main issues are quite coherent there, so there are no breaks like this issue is important now, but then it declines. For priorities, it's quite a rare case for such situations. And to finalize with the challenges namely for our role as a mission and as a ministry in the process, because we are not doing justice by ourselves. We're not doing rule of law by ourselves. We are communicators between our national authorities who do it, EU, which is our counterpart here, and making them both understand the arguments and present arguments of each other. And in this case, what is important? Our internal capacity. When we speak about human resources, when we speak about people staying within the national institutions for a number of years and having necessary experience, this is a challenge, because in some cases, for example, for the Ministry of Justice, you have the changes of the team, they assume a reform, and after that you have the changes of the people. It's not that they don't want to do, the next ones will not want to do it. They will have a different vision of that, and they will sincerely have a different vision. I have seen a couple of ministers and their teams changing, and when you have such changes, you differently some elements, and then you try to revise them during the process. And here, political part with the minister changing, it's one part of the problem. But I mentioned also the team part. If you, stability at the Ministry of Justice as a number of officials, there is a core team which is quite experienced and is there, but this is relatively small, so we are speaking not about too many people, and they are normally overloaded with the work. So this is about internal capacity, and it is as a challenge. The second part of this internal capacity is also working with the Council of Europe and with the EU specifically, knowing exactly what we need and what to ask for specifically according to the mechanism in which EU and Council of Europe work. Because this is once again our task. When I mentioned peer review from 2015, 2016, this was our error, that we didn't specify exactly what is the mandate, what is the terms of reference, what exactly do we want to be assessed, and what kind of recommendations we would like to get. So to be more specific, not to ask for general things. And this is one additional challenge internally for us, which is linked with the experience. The third one would be the politicization of the process, sometimes, not in all cases, internally when the process is linked with political decision, but this is in many cases. And at the same time, at the EU level, I mentioned the example with the Constitutional Court and declaring the reforms which have been positively assessed by the EU unconstitutional, and at the same time the peer review part, which was a request specifically in the made specifically in the political context in which Republic of Moldova was then. Is it possible to exclude politicization as such? I don't believe in that. So to be really clear, we will always have politicians from both sides. We will always have people who view this differently, but as a public servants, we try to put the relevant analysis and recommendations at the table, and here strengthening the capacity step by step, you can get to the positive results. And one last thing, just to finalize on the rule of law, long-term, hard process, but which step by step brings positive results, and not only on the at the level of legislation, but also at the level of implementation. As I mentioned, the courts and the control upon the government, I will just mention the case of COVID, the situation which quite complicated, but even in this case, in my country, Constitutional Court declared that the procedural, for the procedural reason, a law promoted by the government as unconstitutional. It was the law on support for the citizens and for the business in the times of COVID. But even in this situation, even knowing the public pressure and all of that, court decided, and it was clearly explained why, because in that case, government shouldn't do it by themselves, by assuming responsibility, but should go to the parliament. Bearing in mind that we have also the colleague from Romania, Ramona, so we had a similar case in Romania too, and in both cases, you didn't have bad will from the government or bad will from the president. But in both cases, you had a judicial control over the actions. And at the same time, once again, we have not only at the Constitutional Court, we have some appeals to normal courts for the decisions taken during the COVID crisis. We have had an exceptional state. So the state of urgency was declared and the decision were taken by specialized bodies. But even there, we have situations when people went to the courts, and now we have on the examinations such cases. So the judicial control from that perspective, from the perspective of independence from the government, we see even during the COVID on concrete cases when really important sensitive decisions of the government could be overruled.
Thank you, Igor. Amandine, would you like to take it further? I just want to say that we have Humbert and Emmanuel here. So I think perhaps, Amandine, without further ado, given the time limitations we have, Humbert, with your big experience from the Council of Europe, having been there for more than 25 years, as well as your experience with the UN International Criminal Tribunal for Rwanda, as well as working in Bosnia and Herzegovina. It's over to you.
Thanks, Andrew. Do you hear me? Okay, good. So thank you and good morning to all. Hello to colleagues I know and good to meet the others. Ramona, thank you for your assistance. in helping me to be with you. I think two things that I learned from the confinement. One is how to use the IT equipment, but certainly this one I didn't try yet. So thank you for leading me through. And the second is to be patient when it doesn't work. So thank you. I think it was useful to speak after Igor, because basically, Igor, you gave already some very good concrete examples of what is understood in terms of rule of law and how it actually works or how the cooperation between international organizations such as ours and a specific member such as yours work. So I would limit myself to a few generalities, maybe on what how we understand in the Council of Europe rule of law, not how we define it, because we do not pretend to define it, but how we work with it, and then how we translate it into, in effect, actually, with and in our member states, and then a few words on cooperation with countries or with the EU in particular. So basically, as we know, and as you said, Igor, also, there is no clearly defined legal definition of the rule of law. So it's basically a construction that organizations and countries and academics also do to have it short. The most comprehensive analysis of the elements of the rule of law has been done by the Venice Commission a few years ago under the format of the rule of law checklist, which is a document that has been prepared by experts of the Venice Commission and then endorsed by the full committee of the Venice Commission with these, I think, 50 or 51 members, and then formally endorsed by the Committee of Ministers of the Council of Europe and the Parliamentary Assembly. So basically, it is the most widely recognized, not definition, but analysis of the constitutive elements of what we think is the rule of law. It proposes 5 main principles that should be respected by members or institutions when applying rule of law. I would name it shortly. First one is legality, principle of legality. Second is legal certainty. Third one is how to avoid misuse or abuse of power. The fourth one is about non-discrimination and equality before the law. And the fifth one, which is one key element in many countries, it is about justice, an independent judiciary, fair trial, access to justice. The practical beauty of that checklist is that, as the name indicates, it is a very practical instrument which is proposed to anyone in assessing the status of a rule of law in a given country, region, or whatever. So it is a practical tool proposed to governments, academics, civil society, NGOs, but also for our institutions ourselves in the Council of Europe when we approach and discuss elements of rule of law with our partner countries. The checklist also proposes 2 main challenges to the rule of law. One is corruption, and the second is personal data collection and surveillance. The checklist then proposes elements how to assess that members have appropriate measures to fight these threats to rule of law, corruption, data protection, and so on. So a very practical and I think comprehensive toolkit which give all the constitutive elements of each of the principles. Now that's fine. I think everyone can agree that it is fine and beautiful. Concretely, how does it make a difference? There we have to go back to our main characteristics of working. In the Council of Europe, we work mostly through legal norms. So it's quite a legalistic and technical approach to these same elements of rule of law. The most important work is done through the conventions. Most famous is, of course, the European Convention of Human Rights, but then all the sectorial conventions we have, dealing with corruption, money laundering, terrorism, addressing various forms of crimes, but also fight against torture and ill treatment, trafficking in human beings. Now, that's also a question where the limit is between what we call rule of law and fundamental rights. It's somehow a kind of permeable border. For instance, we always are confronted with the question about freedom of journalism, freedom of expression, and media. Is it more human rights in terms of freedom of expression, or is it more rule of law as a kind of check and balance vis-à-vis the governments? Well, it's somewhere in both elements, I believe. So in addition to the conventions, we of course have our monitoring bodies which work with parties to these conventions on monitoring the respect of the conventions. Most important monitoring body is of course the Court of Justice vis-à-vis the Court of Human Rights vis-à-vis the ECHR. But then many of our new conventions have monitoring bodies. We have, for instance, Greco, that has been mentioned by Igor already, on corruption. We have Monival on money laundering and financing of terrorism. We have CPT on the prevention of torture and inhumane and degrading treatment, and many others. But the common feature of all this monitoring is that they do and they carry on on-site visits. They go to the countries, they meet with government, of course, officials, but also any relevant partner they would find in the country. And then the report is discussed within each monitoring committee and adopted by the full committee. Venice Commission has been mentioned already also by Igor. It's our constitutional expert body. They are not linked to any convention, but they are considered as being the body with the highest expertise on constitutional matter. It is being seized on very specific matters related to developments in countries, but can also address more transversal issues. By the way, the Venice Commission will issue, I think, next week or in 2 weeks, an overall study of the emergency measures taken under COVID-19 and their compatibility with the European standards. So that will be publicized very, very soon. In addition to the conventions and the monitoring bodies often linked to these conventions, we have our technical assistance program, which has been mentioned by Igor also. Many of our programs in the countries of the Eastern Partnership and of the Western Balkans are funded by the European Union, by the European Commission, because we obviously have a joint interest there. The Council of Europe acquis is certainly an important part of the Copenhagen criteria for accession countries, and indeed is part of the in the Eastern Partnership framework of the different agreements between the EU and the different partner countries. So the effect of our system, convention monitoring and assistance, has been quite remarkable in the long term over European integration process. I think the long-term perspective here is important, notably because of the fact that we don't have any sanction mechanism. So the whole work is about cooperation, persuasion, dialogue, and peer pressure. So it's a very long-term process that we've been working throughout the continent. Certainly, a big transformative effect has been seen in the eastern part of Europe after the fall of the Berlin Wall, where the case law of the court and the whole process of dialogue through the monitoring bodies has played an important role. It's certainly not finished. We certainly have difficulties in many countries, be it EU countries or non-EU countries. Actually, throughout our membership, we have many rule of law challenges. They can apply to any of these principles, but I think one of the key elements certainly is linked to the judiciary and checks and balances. And we see that certainly now in the current status of emergency measures in many countries, the judiciary has an important role to play, and access to justice and efficient justice in these current circumstances is certainly not an easy part. What can I say else? Maybe, Andrew, I can simply stop here and then have more time for exchanges on particular topics if you like.
No, great. Thank you, Humbert, for giving us a scope of what the Council of Europe is doing, and also your own interpretations of those said issues that you are dealing with. Emmanuel, welcome. If you can just switch on your camera, then we can see you. I see you are still linked. Emmanuel is a lawyer by training. He's working at the Secretariat of the Organization of African, Caribbean and Pacific States. He has also been a legal advisor at the Commonwealth Secretariat, so he brings a lot of institutional experience. Emmanuel, over to you.
Thank you very much, Andrew. Do you hear my voice? A presentation of Igor and the IDIP also, and giving a broad picture about the way the European Council or the EU itself operate within the ambit of the rule of law. I'm going to look at it from the developing countries' perspective. But having said that, I believe that the rule of law is a durable system of laws, institutions, norms, and community commitments that delivers accountability, just law, open government, accessible and impartial dispute resolution. Within this context, accountability means that both the government and private sector or private actors are accountable under the law. The laws need to be clear, publicized, and stable. They apply to everyone. They protect fundamental rights. The process which the laws are enacted, administered, and enforced are accessible, fair, and efficient within the context of the rule of law. Justice needs to be delivered on time by competent, ethical, independent representatives who are accessible, have adequate resources, and reflect the makeup of the community they serve. Having said that, it is not clear in defining what a rule of law is. The rule of law is almost everything within the context, as I've mentioned, within the context of a durable system. One of the speakers have already mentioned the checklist of the rule of law, which the United Nations has developed. And these checklists are a standard, is part of international standards that regulate rule of law in most countries. I would not dwell into it deeply, but this is a clear this thing. It is a clear standard which countries, adopt in terms of trying to reform their legal systems and provide quality service to people and build trust in the legitimacy of their government. Where if you go to the transregional level, like if you look at Commonwealth, which is an association of 54 countries around the world, they have also developed a norm of the rule of law into their understanding. In 2003, the Commonwealth Heads of States developed what they call the Latimer House Principles on accountability of the relationship between the three branches of government. The objectives of these principles, which they developed, is to provide, in accordance with laws and customs of each country, an effective framework of implementation by government. The Commonwealth sector does not impose these kind of norms on all the Commonwealth countries, but it is a principle which, like a soft law, which they expect their member countries to adopt. And some of the soft laws and issues that they put forward within the context of the three branches of government, the executive, the judiciary, they see them as a guarantor in their respect in the sphere of the rule of law and promotion and protection of fundamental human rights and the entrenchment of good governance based on the highest standard of honest probity and accountability. The judiciary in the Commonwealth context believe that the judiciary, the parliament, should fulfill their respective but critical role in the promotion of the rule of law in a complementary and constructive manner. An independent, impartial, honest, and competent judiciary is integral to upholding the rule of law. These norms, which I have just mentioned, it is also incorporated in most of these Commonwealth countries' national constitutions and legislation, consistent with the Human Rights Convention and international law. In the Commonwealth, a member country which violates clearly what they call it, the Harare Commonwealth Declaration, it is a principles which the heads of government have developed. They call it, it was developed in 1991. It's called Harare Commonwealth Declaration, which set out the fundamental principles of human rights, rule of law, accountability, and all. It set out like a checklist, like the UN type of checklist. And any government in the Commonwealth which violates some of these principles are taken into account, especially in the event where they overthrow constitutional government or democratic elected government. Appropriate steps are taken to express their collective concern of the Commonwealth countries and to encourage that country to restore of democracy within the reasonable time frame. This same concept can be found in the ACP group of states, which is now the Organization of Organization of African, Caribbean, and Pacific Group of States, which is the largest transregional organization in the world. The organization has its links with the European Union, and we have a set of rules and regulations that govern both sides. And therefore, you could find out that within the context of the partnership agreement, which is a legal instrument, which has a bilateral legal instrument between the member states of the 79 member states of the Organization of ACP Group of States and the European Union, you find out that there are various principles that are fundamentally can be found in that agreement, especially within what they called the political dialogue between the parties. So Article 8 of the Cotonou Partnership Agreement set out the modalities for such a regular, comprehensive, balanced, and deep political dialogue when there are issues whereby a member government has violated the essential element which exists in Article 9 of the Cotonou Agreement, which means the member country which violates those principles in line with human rights, democratic principle, the rule of law, and fundamental elements regarding good governance. Then, in that sphere, there is a political dialogue within the context of the ACP group, which is the Organization of ACP states now, will enter into some form of dialogue with the EU in order to address some of these issues. And some of the core issues also can be found in Article 96 and 97 of the Cotonou Agreement, which aim at finding solution acceptable to all parties in order to avoid sanctions. So these are some of the transregional norm that exists that regulate the African, Caribbean, and Pacific group of states within this accord. Therefore, I'll just move strictly also to the regional level and look at the rule of law in the context of Africa. The rule of law is safeguard against arbitrary and abuse of power. It enforces limitation on power of the state and all its institutions and government. The rule of law plays a crucial role in protection and promotion of human rights, democracy, good governance in Africa. It is an instrument for promotion of social and economic development and social justice. Of a particular importance within the context of the African continent is the African Charter on Human and People's Rights, which was adopted in 1981 as a regional treaty by the Organization of African Unity, which is now African Union. The Charter emerged at a time when many African countries were emerging from colonial rules, armed conflicts, civil war, authoritarian rule, military coups, and dictatorial regimes, and the rule of law, which has been broken down. It is on this basis that Part 1 of Article 1 of the African Charter call on all member states of Africa to recognize the rights, duties, and freedom enshrined in the Charter and to adopt legislative measures to effect to them. African Charter enumerates a number of civil and political rights attributed to individuals, many of which are formally recognized in many African constitutions. These include the right to non-discrimination, the right to equality before the law, and equal protection of the law, the right to expression and dissemination of opinion, the right to freedom of association, the right of assembly, the right to freedom of movement. In respect of the right to life and the right to liberty, it is clear that no one may be arbitrarily deprived of these rights. And Article 6 includes prohibition against arbitrary arrest and detention. Article 7 provides some procedural safeguards in criminal trials, which include the right to have one cause heard, the right to an appeal, the right to presume innocence until proven guilty by a competent court or tribunal, the right to defense, including the right to be defended by a counsel of one choice, and the right to be tried within a reasonable time by impartial court or tribunal. However, it has been pointed out that certain additional safeguards found in both the European and American Convention on Human Rights are missing, and these are broadly related to the accused being notified in advance of the charges against him, the right to request witness to attend the trial, a guarantee of legal representation paid by the state if accused cannot afford to hire a lawyer, and the right of the accused to aid where there is a language problem. These are some of the issues that are not reflected in the African Charter on Human Rights, which profess the path of the rule of law within the context of Africa. And therefore, most of our legal system in Africa do not have what you call legal aid in order to support victims that do not really have money to hire a lawyer. And one of also the problems also that is within the context of the African Charter that have been criticized on the basis that it allows national law to limit or derogate from the right in the Charter. In the Charter are a number of so-called clawback clause that compromise the realization of the rights guaranteed under the Charter. These clawback clauses are clauses that exist in most African constitution within, and they emanate as a result of the provision within the Charter, which means they can suspend a constitution, and when they can suspend a constitution during the time of crisis. So that is some clause which, in fact, the whole most intellectuals have actually criticized. And having said that, also the African countries also have specific problems within the context of the promotion of the rule of law. Some of them has been identified by a judge in Ghana called Judge Kofi Datiba he identified the following problems relating to the judicial system in Ghana. He is saying that the time taken by judicial process have been a source of complaint by business people in most developing countries, including Ghana itself. The perception is not held by business people alone, but also by many others from all walks of life who have sought the assistance of the court for the resolution of commercial disputes and other related issues like criminal disputes and things. There are also persistent complaints over delays in dispensation of justice and inability of court bailiff. These are some of the issues that needs to be ironed out. These are some of the issues that if we from the developing countries, especially in Africa, do not iron out within the context of addressing this problem within the judiciary, it will undermine the rule of law. And so within that context, I will break off, and if anybody has any question, the person can ask me. Thank you very much.
Thank you, Emmanuel, for giving us that snapshot, moving from the Commonwealth to the ACP, then to Africa, and also the Ghanaian perspective. Amandine, I give over to you maybe to moderate the session with the other colleagues and see what interesting questions and more so interesting responses our panelists might have.
Sure. Thank you, Andrew. Thank you, everyone, for your precious contributions to this roundtable. Does anyone have a question, maybe? You can raise your hand, or you can take the floor directly. We're not so numerous, so yeah, you can also raise your hand physically. Yes, please.
So, all right. So first of all, I would like to thank all the speakers. It was really interesting. So I was, first of all, maybe I should present myself. So I'm Guillaume Bremter, a student, and I was till working as a Blue Book trainee at the Commission, much more on the innovation side for Horizon 2020 funds. I was listening carefully to Mr. Rabley. I was really interested in the interaction between the EU, the Council of Europe, and also Moldova in contributing to the rule of law in Moldova. And so I was checking inside the Council of Europe website, and I found this Partnership for Good Governance, which is divided into two parts. And so I was looking at those projects, which lasts for over 3 years, and the second part for only 2 years. And so my question is as the following: it's a long process, you know, to foster the rule of law in a country. And so because you have to involve the civil society, but also there is many risks due to political uncertainty, by example. So after those projects, or the Partnership for Good Governance part 2 or part 1 is finished, completed, or considered as completed, is there any follow-up for the project, which only lasts for 3 years, which is quite short? So this was my question, which I think Mr. Rabi and also Mr. De Piole would kindly answer. Thank you.
Thank you very much. I don't know if you want to answer right now, or if we take another question. What would you prefer?
As you prefer.
If you're ready to. Okay, we'll have a second question. Let's go for a second question, and then we come back to you for the answers. Thank you. Yeah, Olivier. Yes, please.
Okay. Good morning, everyone. I want also to thank the speakers for the good information that have been given to us. I have 2 questions. The first one is to Mr. Jarrett. I would like to know whether Canada has a specific approach in promoting the rule of law in its relationship with developing countries. Does Canada join other international actors like EU, like the World Bank, or there is a specific Canadian approach in that sector? My second question is to the legal counsel of the ACP organizations. You've talked about the importance of Article 98 of the Cotonou Agreement in the promotion of the rule of law in ACP countries and specifically in African countries. How do you evaluate 20 years after the signing of that agreement, the impact of this article on the promotion of the rule of law in Africa? Thank you.
Thank you very much for these two questions. I propose the following. I can give you a few minutes to answer to each of you, to answer the questions. So maybe chronologically, Igor was first on the line, then maybe Humbert de Biolay, if you want, and then we'll go on with Canada and our colleague from Canada, and then with Emmanuel Opoku. Igor.
Yes, with regard to the Partnership for the Good Governance, this is exactly one of the examples of joint Council of Europe, European Union cooperation with the Republic of Moldova on the rule of law and human rights and democracy, because there we have a larger pattern. And this is not the first one. I would say this is not the last one we would have, but here on the details, I suppose the colleague from the Council of Europe will be more useful, namely because I work with the EU specifically. I know about those programs with the Council of Europe, but here I'm not the best specialist possible. Thank you.
Sorry. Yeah.
Concretely, would there be a third or a next PGG, that's the acronym of the program, after this one ends? Probably, hopefully, I would think so. But let's come back to the essential. The countries of Eastern Partnership are all members of the Council of Europe. And as a consequence, they are all party to the main Council of Europe conventions addressing human rights and different rule of law aspects. So that is the premise, if you like. After that, we have our cooperation programs. This program is one among many other cooperation programs we have with the countries. In Moldova, for instance, but in the other Eastern Partnership countries and other countries, we have a series of technical assistance programs that we implement to assist the country to respect their commitments vis-à-vis these conventions. So PGG is one program. It's a big, huge, very important program. The beauty of it is that it is conceived with, with the three parties, the countries, the EU, and the Council of Europe. So it's a common understanding of what needs to be done in order to respect the agenda of respect of rule of law and human rights. So we have a common understanding there, a common interest there, and we have a very useful and fruitful cooperation, I would say, because at the different steps of the implementation of the programs, we have the three parties together speaking about the same challenges, the same difficulties, or the same success in the reform agenda. These kind of assistance programs in these countries, Moldova and all the others, these kind of programs exist for, I think, more than 20 years. This program, this specific program, PGG, is a particular program because it's heavily funded, it's multi-annual, and it's regional, which covers the whole EAP region. So that is important, and that has proved very, very useful and powerful as a program. So yes, we hope it will be continued. That will be part of the discussions we will have in the Commission, probably also in the light of the new Eastern Partnership priorities that will probably be developing after the next summit of the Eastern Partnership heads of state and the EU. I hope it answers the question.
Just one more thing to add for that, because you mentioned namely just Partnership for the Good Governance, but before that you had the Council of Europe Facility for the Eastern Partnership, exactly what the colleague said that it haven't started now, and it will probably continue. But here, just what I wanted to mention, this is just a technical way to do things, because the priorities for the Eastern Partnership are defined thematically, and then together, European Union, we as partner states, and specifically in the case of Rule of Law Council of Europe, we discuss what could be the means. Because if we speak about rule of law, for example, in the Eastern Partnership, PGG is not the only tool applicable and applied by the EU. So here, this is one specific case which involves all three, but at the same time, for example, you have rule of law panel, which is organized with the participation of the Council of Europe, but there you have DG Just and DG Home in lead, and there you approach at the expert level specific issues once again. But here it's just selection of the tools. So thematic focus remains the same. The rule of law will remain for thematic focus of the Eastern Partnership after 2020. This is mostly, let's say, it could be assumed that it will be like that. So we have seen it from the proposal of the European Commission for priorities post-2020, and basically the EU member states also supported this approach. And from what I know from the partner states, but let me speak for Moldova, we will also support this approach. So this cooperation on the rule of law, it will continue. But the concrete tools, how will the project be named? Well, what will be the concrete involvement, concrete budget, concrete topic for a seminar or a study? These to be decided. But the focus as such, the broad focus will remain, and this format for EU, us, Eastern Partnership states, and involving Council of Europe, it will most probably remain, so, because it's proved to be efficient previously, and we will have the same thematic focus in the future. So here it will be just discussion how to work, not on what topic as a big one to work.
Thank you both for your comprehensive answers on this partnership for good governance. Maybe Jared, you want to take the floor for the question on, if there is a specific approach of Canada for its policy with developing countries.
Yeah, sure. Thank you very much for your question, Mr. Kenhago. If I pronounced that correctly, apologies if I did not. It's a very good question. I could probably spend about an hour on that, but I'll try to limit it to like 2 minutes instead. Essentially, I just start off with, for us, we see these things as part of a toolbox, and I don't think you can separate, particularly part of the fact that there's not a really legal definition per se of rule of law, that we treat rule of law as part of an overall approach on democracy and human rights, which are much easier to delineate in a certain way. But essentially, it's about functioning societies, stable societies where everyone has a chance to live with dignity and to create equal opportunities and sort of an inclusive society. So really, hallmarks for us are diversity and inclusion as part of our society, of our approach. And you know, it's kind of, we have our foreign policy side and we have our development side, and we're a long-standing partner from a development perspective with most of the developing world. We're by no means the world's biggest donor, but I think we're a very consistent one and have been there for decades. And I think sometimes where we get into an advantageous position in terms of our ability to maybe promote those values is from a simple question of perceptions. And I'm going to be a bit simplistic here, but you know, what I do know of my limited time spent in relation to Africa is that often we're not seen to have a hidden agenda compared to some other countries with more of a colonial history. We're seen as being a partner that really is just truly there. I don't want to say altruism, but we're really there to help, and that we're not trying to promote commercial interests on the side or something like that. It's never perfect, but we do the best we can. I think much of our approach in terms of is linked to capacity. It's about building institutions that are resilient and that respond efficiently into the needs of citizens from all walks of life. So a lot of it is boring stuff like accounting and auditor generals capacity building. It's about training technical assistants to civil servants to make sure that they're able to fulfill their duties. It's a very slow process. It takes a very, very long time. but we do see some important progress in countries where we do work, and that's always very promising. Occasionally there's backsliding, and that's unfortunate. Rule of law specifically is interesting from a promotion point of view, because I wouldn't say we've ever delineated it so much in the sense of it's more of a kind of a direct effect of the work we're doing elsewhere on democracy and capacity building, institution building, and human rights. But that's changing a little bit. I think we're trying to give more of an overt focus there in our foreign policy. So at the moment, in case you haven't heard of it, our latest policy documents for our development is called the Feminist International Foreign Assistance Policy of Canada, and there's a really strong emphasis on girl and women's empowerment, and that's not to say that to the discredit or to undermining of boys and men in that equation, but we really feel that's an area where Canada can bring greater emphasis to be able to achieve equity in society that helps build more resilient and prosperous and inclusive societies, and that obviously has a strong impact on rule of law. Secondly, we're also working at the moment, we don't really have a kind of a policy statement per se, but we are also following a feminist foreign policy as well at the moment. There's no one speech that gives that out, but it's basically of trying to look at these questions through a gender, but not just a gender, but what we call it a gender-based analysis, is kind of a looking at the intersectionality of all of these components. So for example, we now have a requirement anytime we develop a new policy within Canada that we have to do what we call a gender-based plus analysis on the impact or potential impact of that policy, including our development assistance and foreign policy, on not just on different strata and different sub-demographics of society. So it's called gender-based analysis, but it actually includes Indigenous persons, people with different LGBTQ elements, socioeconomic factors and things like that. And I think that's really helped us get out of the kind of confirmation bias, the different prism we look at our policy sometimes, and make them much more inclusive and diverse. And Canada is a big believer that diverse societies where everyone has their role and their equal rights before the law and ability to pursue the life as they deem fit makes for more resilient and stable and prosperous societies. And we're a big believer in multiculturalism, and I think the relative success of Canadian society in that regard for us is an affirmation of that policy. And then otherwise, I'd just say I can't think of another country that is a member of more multilateral clubs than Canada. We're a member of the Commonwealth, Francophonie, obviously the UN, on the Security Council from time to time. We are observer with the Council of Europe, so even one of the few non-European countries that have that kind of capacity. We have a very strongly developed relationship and growing all the time with the African Union, and those kind of that mix of that different toolbox of working both multilaterally but also in our own bilateral programming and working with a regional approach wherever possible. We're not magically changing things from day to day, but I think all of those different kind of tools in the toolbox combined make for a more powerful and more effective foreign policy and development partnership with our key partners in the developing world. And we hope to do more as we can. If you have any good ideas of what we could be doing better or more of, please let me know.
Thank you very much, Mr. Alexander. Emmanuel Opoku, would you like to answer the last question?
Thank you very much. This question came from my own colleague who understands the issues as I do. Within the context of the question he asks, I think it is in the context of Article 96 and then 97 of the Cotonou Partnership Agreement, which is also linked to Annex 7 of the Cotonou, the same agreement. These articles are also linked to the Article 8 and Article 9 of the same agreement, and it talks on the issue on essential elements, and it provides the procedures for holding consultations and taking appropriate measures as regard human rights, democratic principles, and the rule of law. And his question is that he's asking the question he asks is a pertinent question. After 20 years, is there any progress within the context of the Cotonou Agreement? He knows that there is negotiation going on and it has not been concluded yet. And therefore, these are some of the issues also that reflect in some of the proposed articles which the ambassadors are discussing. And I would say within the 20 years of the Cotonou Agreement and the support that we have received from the EU, there is Africa has made a lot of progress in terms of the rule of law, accountability, and then creating a democratic society. Africa is not Africa of before 1981, when we got African Charter on Human and People's Rights. Having said that, Africa has its own problems, but then the problems are within the context of the promotion of the rule of law through the justice system. And that is where we need to do a bit of more work. I heard our Canadian colleague talking about support for Africa in various areas of the rule of law. I will urge him to support the African, Caribbean, and Pacific states, to support them in their judicial reforms, because the judicial reform is essential to the promotion of the human rights and the rule of law. Especially, there is a need to fast track the court system. There's a need to put alternative dispute resolution to be able to iron out problems for the ordinary people within the context of the judicial system. There are moves in some parts of Africa where they are using these systems, but we need to do a lot of work within the context of judicial reform. I agree with my colleague that there have been a lot of progress, but more needs to be done. After 20 years, Africa needs to wake up and also come up with their own rules and regulations, and to help the various African countries to institute mechanisms that will defend the rights of the people within the context of human rights. And therefore, one of my proposals, one of my recommendations to him is also to fight to establish national human rights institutions within the context of the Paris Convention within the UN sector, to be able to create national human rights institutions in Africa to defend the ordinary people and to defend the rights of people. It is also an avenue, a channel which can be used also to promote human rights. This has not been done, and I think that is a challenge to our colleagues from developed countries who want to help us in Africa, Caribbean, and Pacific, to support us to reform the judicial system, to support us also to strengthen our national human rights institution and other systemic institutions that we have in Africa, especially the criminal justice systems and things like that. With this, I think I will stop there. Thank you very much.
Thank you very much. Thanks a lot for this clear speech and actually clear application of our topics this morning about how to go from theory to practice, basically on rule of law. We are clearly over time, so I'm not sure we have extra time for another question, unless there is a really pressuring need for this last question. Maybe not. Then I will give you the floor, Andrew, back for the last words, maybe.
No, Amandine, thank you for co-hosting. I can just say to everyone, thank you for taking time on a Saturday to share your experiences, your knowledge, and also to guide our students. I think this was a very rich exchange. It's a pity that we don't have enough time, but I just can say that on behalf of the Institute of European Studies, thank you for being with us, and we will press on your button. Don't worry about that for next of our next series of conferences, because I think there is still a wealth of knowledge that you have and that you can share, and you showed today that you are willing to share that with especially the young people, the future that we have. And just to conclude and say, the rule of law, in my view, it affects everything about where people work and how we live. Thank you. Have a nice rest of the Saturday. Keep healthy.